Hey, welcome to today's video. I'm Richard Chapo. I'm a privacy lawyer in San Diego, California. And today we're taking a look at the death of behavioral advertising. Is it really going to happen? And the genesis of this question is the California Consumer Privacy Act, CCPA, is a new privacy law in California. It goes into effect January 1st, 2020. Now, the CCPA gives California residents quite a few new rights, if you will, over the collection and use of their data, their private data. So information such as their name, email address, biometrics, their geolocation, their web trafficking history, pretty much anything these days that seems to relate to personal information. The definition in the CCPA for personal information is so broad that it's literally a task to find something that wouldn't be covered. Now, the CCPA contains these rights, and one of the key ones that's new, and we haven't really seen it anywhere in the world, is the do not sell my information right. So you're going to start seeing links on the footer of various websites and apps that will say do not sell my info. And you click this link, and it will take you through to a page, and you, as a consumer, a California resident, can submit a request telling the company, stop selling my information. At that point, the company has to stop sharing your information with other parties. And it also has to communicate that directive to third parties who it has shared information with, your personal information with, and they must stop using it. And this is where things get a little crazy with behavioral advertising. And the reason for this is, let's say you have a website and you have, let's say it's a blog post, it's 2,000 words long, and you have ads, pasted within the post at different, areas, and they consist of behavioral advertising. You're using a third-party ad network, and those are the kinds of ads they're placing. Now, behavioral advertising is very valuable. It tends to convert at much better rates than traditional advertising, contextual, what have you. And so that's a smart move for you. Now, the problem, though, is how do you communicate the do not sell information request with those parties, with your ad network? Because the ad network traditionally is not the only party involved in producing that behavioral advertising. There are actually usually 6 or 7 other companies, sometimes called data brokers, who are supplying information to that ad network to help them understand, a profile or just generate a profile for the individual looking at the page. And that creates a couple problems. One, how do you, as the website, communicate this do not sell information request to those data brokers? You don't even know who they are. All you know is the ad network. And so how is that going to work? And then the second problem, which is also kind of interesting, is when a person comes to your website and they exercise this right, they're going to essentially fill out a form. So you may have their name, their email address, and that kind of a thing. Well, your ad network does not have their name and email address. That's not how behavioral advertising traditionally works. Instead, what they do is they assign a unique identifier, say something like AD213B, to a person. And then whenever they see that cookie or whatever tech they're using to track them, go to other sites and whatever, well, they add that information to a profile under that identifier. And so for me, for instance, let's say I'm looking for a truck. I live up in the mountains. I want to buy a Toyota truck. And so I've visited a number of different sites looking at trucks and pricing and that kind of thing. Well, my behavioral profile is going to say, this guy really likes trucks. And so whatever websites I go to, they're going to show me truck ads, but they're not going to know my name or my email address. That's not the way that they're going to collect that information. So the question then becomes, how do you translate that do not sell my information request form into a form that the ad network can use to identify, whatever profile it is that the request is coming in for? And it's not entirely clear yet how that's going to work. So we've had a couple of different approaches that have started coming out. One is Google. Google has gone with a restrictor processing approach. And as a website, if you use their services, you can select this designation. You probably received an email already. And essentially what it does is it removes all personal information from their software and from their databases in relation to that person, in relation to the services they provide you as a business. So analytics, the various ad networks that they have, those kinds of things. And they essentially are going back to a contextual advertising approach. And contextual advertising, if you don't know, is simply the ads when they're showing on a page on your website, they're shown based on the content on the website, not on the profile of the person viewing the page. So if I have a profile showing I'm interested in Toyota trucks, but I go to a website and it's a bird watching website, and I'm reading a bird watching article for some reason, it would show me ads about bird watching, not Toyota trucks. And that's the general idea. And so that seems to be Google's approach. And the idea there is they're saying, well, we're not collecting personal information, so it doesn't matter. And you don't have to exercise this request with us. Now, ad networks, as you might imagine, not really keen on that approach. So they're taking different approaches to trying to somehow fix the functional problem. So the IAB is probably the biggest group that's working on this, the Internet Advertising Bureau. And they're trying to create a pass-through code command, maybe a cookie, I'm not exactly sure how they're calling it, that apparently somehow you're going to submit on your form. So when somebody does a do not sell my information request, they'll be able to connect that person to the unique identifier profile in their database. And they will then move that request down the line, sharing it with the data brokers and what have you. And okay. I have no idea if that's going to work. I don't really know the functionality of it, but what I would suggest is that if you are showing ads on your site, you need to go talk to these people, talk to your ad networks and find out what's going on, find out what they're doing and what you need to do. And it's kind of imperative because if not on January 1st, technically you could be in violation of the CCPA, and that's not really where you want to be. So is all this going to lead to the death of behavioral advertising? I tend to think it is. Now, maybe not the death, but certainly there's going to be a significant pullback and limitation placed on behavioral advertising for a short period of time. The IAB approach, while it may sound great, it actually hasn't been approved by the California Attorney General, and I haven't seen anything in the California Attorney General regulations that suggests that the AG's office would approve it. This is just an independent initiative by a for-profit company. You could follow it to the T, and if the AG says, no, this doesn't pass CCPA muster, well, there you go. So I think behavioral advertising is definitely going to take a hit, probably for 6 months, maybe up to a year. However, I wouldn't go into full panic mode if you rely on behavioral advertising because, unless you're brand new to the internet, you should know by now, innovation wins out. Innovation wins out over regulation almost every time. So even if the CCPA effectively starts to kill off behavioral advertising, ad networks are not going away. They're going to come up with a different approach. And maybe they go back to contextual advertising and things are painful for 6 months to 8 months, but eventually they're going to come up with another approach that's going to help them, come up with a solution that will essentially replace behavioral advertising. Maybe it's the same thing called something different. Maybe it's something entirely different. Who knows? That's the beauty of capitalism. People tend to get very creative. But it is an issue that you need to be keeping an eye on. Now, what about the fact that this is only California? Because the CCPA only applies to California residents. I wouldn't rely on that at all, quite frankly, because with laws of this sort, what happens is California tends to be the first state to pass them, and then other states start passing similar laws. We're already seeing this in other states. So it's kind of only a matter of time until many of the other states are going to have similar legislation. We may also see a federal privacy law that incorporates these concepts at some point here in the next year or two. I'm hoping that we do. Federal privacy law would be great because it would create one set of rules for complying, with privacy issues for companies. Right now, we're running into a situation where we could literally have a different law, calling out privacy requirements in every state. And yes, that would be madness because they would not all be the same laws. In fact, we already see Nevada has a different regulation from California. In New York, they're talking about this just nightmarish, situation where sites would be called fiduciaries of their visitors for privacy purposes. Fiduciary is the highest duty under law, is the most restrictive. You must completely ignore your own interest in that situation and only act in the interest of your visitors. So I don't even know how we show advertising. Facebook has already said they can't even operate under that system. So, there's a lot of change going on out there. Now, in that vein, there is a lot of change, and it's important to understand that. And it's not necessarily the end of the world. First of all, California Attorney General is not going to be filing any enforcement actions until probably early summer. And even when they do, they only have a budget of about $4.7 million. And the expectation is they're probably going to go after some big boys to make examples out of them and show all the smaller companies, how to comply. So Armageddon is not hitting January 2nd. It's going to be much like the GDPR. If you were around for the GDPR in May 2018, you probably remember all the doom and gloom procrastinations. May 25th, 2018, it was like the Mayans coming again. We're all going to die. And of course, the date hit and nothing happened. Sure, Google and Facebook got sued right and left, and enforcement actions were filed against them. But against smaller companies, not a lot happened. And in fact, it wasn't really until 6 months later that we started seeing, any kind of enforcement actions. And even then, they were very lenient, the supervisory authorities, because they knew there were a lot of vague areas of the law, the GDPR in that case. And I suspect that'll be the same thing with California. So enjoy your holidays. Don't have a seizure over the CCPA. Do everything you can to get into compliance. But, it's not the end of the world if you're a little late on January 1st. Now, make sure you talk to your advertising networks, whoever you're working with on advertising, and get your act together in that area. Very important. Behavioral advertising is going to take a hit, but it's not the end of the world. Advertisers always come up with something, and I'm sure they'll come up with something to replace it. So the death of behavioral advertising? Not the death, maybe a coma. But you'd be surprised how people come back in the future. It could be like a soap opera, where the bad twin goes into a coma for 6 months and then suddenly awakes, and now he's the good twin and all that kind of thing, for those of you who even know what soap operas are. So anyways, thanks for watching. If you have any questions or comments, feel free to contact me at SoCalInternetLawyer.com, and I'll be happy to help you out. Otherwise, have yourself a good one.